Members of the Senate are focusing on gun rights in the wake of the Supreme Court's Bruin decision.
Everybody has a right if they're a responsible adult.
The U.S. Supreme Court has just issued a major ruling.
Major Supreme Court ruling.
The two most important days for the Second Amendment. Every generation faces a moment that defines its legacy. For defenders of the Second Amendment, that moment is approaching fast. In just a matter of days, the Supreme Court of the United States will make decisions that could permanently reshape how Americans lawfully own, carry, and defend themselves with firearms. These are not just court dates. They are forks in the road for our constitutional rights. The battles ahead are about far more than legal theory. They are about whether a 19-year-old single mother can protect herself in rural Texas, whether a rehabilitated veteran with a 20-year-old felony record will ever be trusted with the right to defend his home again, whether Americans in California, Connecticut, or Illinois will be forced to live under sweeping bans that outlaw magazines and rifles they have owned for generations. And all of it comes down to 2 days, November 14th and November 21st, the two most important days for the Second Amendment in a generation. Please make sure you are subscribed to the channel so you don't miss the fallout from these cases. Let's get into the full breakdown. Section 1. The Supreme Court's growing to a docket. The United States Supreme Court has already agreed to hear 2 Second Amendment-related cases this term. But these are only the beginning. What few people realize is that behind the scenes, dozens of major 2A petitions are now sitting on the court's desk, waiting for one of 2 outcomes: a green light for full argument, or a quiet rejection that lets lower court rulings stand. Several of these petitions are now scheduled for an internal conference on 2 critical days, and the outcome of those meetings could determine whether gun owners nationwide see new protections or a wave of judicial apathy that emboldens anti-Second Amendment states. Key facts. The Supreme Court has accepted Wolford v. Lopez and United States v. Rahimi. Dozens of additional 2A petitions are up for conference on November 14th and November 21st. Petitions must get 4 votes to be granted a full hearing by the court. The sheer volume of pending Second Amendment cases is unprecedented, and the next 2 Fridays could shape which of these cases become national precedent. Section 2. Age restrictions on gun ownership, 18 to 20-year-olds. One of the most urgent categories of cases involves federal restrictions that prevent 18 to 20-year-olds from purchasing or possessing certain firearms. These laws are currently applied inconsistently across the country due to conflicting rulings by different circuit courts. The core of the debate centers on whether young adults who can vote, serve in the military, and be prosecuted as full adults should also have the right to purchase handguns or modern sporting rifles. Key cases up for the November 14th conference: McCoy vs. ATF, West Virginia Citizens Defense League, VUS, ATF, Lara v. ATF, NR, AV, ATF. Key issues: whether the federal ban on sales to under 20s violates the Second Amendment, whether Second Amendment rights begin at age 18 or 21. Circuit courts are split, creating confusion and inequality. This issue could impact millions of young Americans who are otherwise treated as adults in every aspect of life, but denied their right to lawful self-defense. Section 3. Felon-in-Possession Law, 18 U.S.C. Section 922 G1. Another massive legal battleground involves the federal prohibition on firearm possession by anyone who has ever been convicted of a felony, even if the offense was nonviolent and decades old. Known as the Felon-in-Possession Rule, this law has generated dozens of challenges nationwide. The argument is simple. Should a person who committed a nonviolent offense in their youth and has since led a law-abiding life be forever stripped of their constitutional right to keep and bear arms? Key cases already heard or pending: Fontawandi v. United States, 5th Circuit; Flores v. United States, 5th Circuit; Moore v. United States, 5th Circuit; Lee v. United States, 10th Circuit; Wise v. United States, 3rd Circuit; Robinson v. United States, 5th Circuit; Aosta v. United States, 2nd Circuit; Red v. United States, 4th Circuit. Additional cases scheduled for the November 14th conference: Staley v. United States, 11th Circuit; Barrow v. United States, 5th Circuit; Jones v. United States, 11th Circuit; Thomas v. United States, 5th Circuit; Osborne v. United States, 4th Circuit; Sullivan v. United States, 5th Circuit; Lusk v. the United States, 5th Circuit; Guyton v. United States, 5th Circuit; Ferris v. United States, 10th Circuit; Reese v. United States, 10th Circuit; Law v. United States, 3rd Circuit. Each of these cases deals with one core question: Can the government permanently disarm people based on past conduct, even when they pose no current threat? Section 4. Illegal Immigrant Firearm Prohibitions. 922 G5. A related but separate issue is whether the government can universally ban undocumented immigrants from possessing firearms regardless of their behavior or circumstance. The question is whether the Second Amendment applies to the people as a broader category or only to legal residents and citizens. Although none of these cases have been granted yet, multiple petitions on this issue are set for conference on both November 14th and November 21st. Key issues: whether the Second Amendment applies to undocumented immigrants, whether status alone without misconduct justifies disarmament, how the law-abiding qualifier from Bruin should apply. This is one of the more controversial areas of Second Amendment litigation and may be less likely to gain traction, but its constitutional significance is enormous. Section 5. The magazine ban case, Duncan v. Bonta. Perhaps the single most watched case among gun rights supporters is Duncan v. Bonta, which challenges California's sweeping ban on so-called large-capacity magazines. This case has been in litigation for years with repeated reversals and delays. The Ninth Circuit upheld the ban, and now the Supreme Court is set to decide whether to hear the case during the November 21st conference. Key facts: California bans magazines holding more than 10 rounds. Plaintiffs argue that ICE are commonly owned and protected by Heller. The case has seen multiple appeals and now rests with the Supreme Court of the United States. If accepted, this case could finally set a nationwide precedent on whether states can criminalize ownership of magazines used by millions of Americans for self-defense and sporting purposes. What happens? Next is in your hands. As these monumental cases sit before the Supreme Court, we are not just witnessing history, we are standing at the crossroads of it. The dates are set, the petitions are in, and the outcomes of these conferences could reshape the Second Amendment for an entire generation. But the fight does not end with court filings and legal briefs. It begins with awareness, it grows with understanding, and it succeeds when Americans like you stay informed and stand ready to defend their rights. So here is what you can do next. Share this video with fellow firearm owners, advocates, and legal minds who need to know what is coming. Drop a comment below: which case are you most concerned about, and what ruling do you believe is essential to protect our freedoms? We break down the legal complexities, give you the straight facts, and prepare you for every challenge ahead. In a world of shifting politics and uncertain laws, knowledge is your first line of defense. Stay sharp, stay lawful, and stay prepared. Until next time,